And I was stating, perhaps admittedly, the Constitution does not provide where does the perhaps if there is a conflict, especially for the Constitution, it's very clear, it is the supreme law. But for the statute, the Constitution does not resolve the question of, at least directly, of what should happen in case of conflict between a statute and international law. I am suggesting that for perhaps a theory or an approach that we may call constitutional baseline, whereby the reference is to the Constitution. The question that is asked instead of, in case of conflict, which one between the statute and the international law advances the most the principles contained in the Constitution? Then that one would automatically be elevated. And I'm not saying that just generally out of my own mind. I would interpret that Article 2.5 and 2.6 reference to the Constitution as the baseline has been provided by providing that under this particular Constitution. So I move to the second issue, which is the Supreme Court stated that international law international law is to fill the gap where there is where the domestic law is silent. That view, in my view, is quite problematic because international law, the applicability of international law is a question that is regulated by the Constitution. And the Constitution is very clear, if I may use that phrase, that international law indeed forms part of our laws if there is ratification in case of treaties and for what the Supreme Court or what the Constitution calls the general principles of international law. So I do not know on what basis would the Supreme Court say that international law is not our laws and we should not consider it. We should only use it when there is a gap in our laws. Then it means that international law is not our laws, because if it is our laws, then it should apply at all time. It is more. It means that it is more of a secondary kind of a source of law. And I have no problem. We can differ at all with the Supreme Court on the issue of saying that international law applies to fill gap. But I wish that the Supreme Court would have shown reasoning in that respect, or at least provided on what basis would they say that international law applies to fill gap when Article 2.5 says that the general principles of international law shall form part of the laws of Kenya without any qualification. So on what basis would the Supreme Court say that international law or suggest that international law applies to fill gaps? So that is another problematic finding that the Supreme Court made. I move to the other issue, which is that the Supreme Court was of the view that Article 2.5 and 2.6 of the Constitution has nothing to do with monism and dualism. And specifically, the Supreme Court suggested that we are still a dualist state. For context, one thing I must state is that on the relationship, the question of relationship between international law and domestic law, it's quite a debatable one. And the debate is quite dominated by 2 points of views. When we are asked the question, what is the relationship between domestic law and international law? The correct answer, in my view, is that it depends. If you are looking at it from an international law perspective, it means going by Article 27 of the VCLT and Article 3 of the ILC articles on responsibility of states in the International Lawful Act. they provide that you cannot use your domestic law, including the Constitution, as an excuse for violation violation of an international wrongful act. And there are plethora of authorities, including the Alabama cases, whereby the court stated that despite the fact that in UK there was an excuse that the law prevented them, that is not excusable under international law. And in general, international law treats national law as only facts. Facts perhaps sometimes to prove opinio juris, our state thinking about a particular issue, or perhaps to generate what we call under Article 38(1)(c) as general principles, yes, of international law. So to that respect, that is how international law views it. When it comes to the national law, the question is entirely left to the domestic law on how to treat international law. And this respect, there are two major approaches that have emerged. I call them majors. I think people talk of different, others talk of perhaps a mixture of the two. And this is a dualist approach and a monism approach, or a monist approach. A dualist approach posits that international law and the domestic law are distinct systems of law. They operate separately, and before any rule of international law can apply in domestic law, it must be transformed to municipal law by use of appropriate machinery. And the appropriate machinery ordinarily would be registration. That's why we have the ICC Act and many other acts domesticating the international treaties. And the other approach, the second approach, is the monism approach. It posits that international law and the municipal law is part of the same legal order, and international law applies automatically. So in case of ratification, then international law would apply, the treaty would apply. So in other ones, we have two dualists talking of the issue of transformation, while monism talking of the issue of incorporation and direct application. I submit that Article 2.5 and 2.6 changed the practice of Kenya from a dual state, or perhaps a silent state, to a monism state. Of course, dual state for some people interpret as if it is the default state. Yes, to a monism state. So, and the reason why I say that, it's good also we look at those articles again, so that at least we have some basis. Those articles provide that international law shall form part of the law of Kenya. And the other one provides that international law shall form part, any treaty or convention ratified by Kenya shall form part of the Kenyan law under this constitution. So the key word is ratification. If you ratify a treaty, then it forms part of the laws of Kenya. It does not require for the treaty to be transformed in any way to domestic law. I know some people have made several arguments. The first argument that I have faced on this is that under Article 21, it provides that states shall enact and implement legislation to fulfill its international obligation in respect of human rights and fundamental freedom. My response to that is that those who state that provisions signify or signal to one's dual state are missing the point, because they are confusing between two issues: the issue of applicability and the issue of implementation. And distinction must be drawn between applicability and the issue of distinction, because an issue of implementation does not mean that the treaty is not applicable. The treaty is still in operation, but it requires some legislation for to give full effect to those provisions, or to give them the meat, or to enable those provisions, not in the sense of applicable, but to operationalize them in terms of the significance or different contexts that might exist. The second argument that is always offered to show that Kenya is a dual state is that the Treaty Ratification Act provides that Parliament has a role to play. I also provide or submit that particular contention is without backing, and it arises out of blurring or a lack of understanding between dualism and monism. And the reason why I say that is that if you look at the participation of the Parliament in this treaty ratification process, it is very limited. It is not transforming the treaty to an act of Parliament. What Parliament is doing is it is giving approval. In fact, what is required is only approval for the minister or for relevant authority to ratify the treaty. And the issue of ratification is always an issue of internal or domestic law. You decide on how you want to ratify the treaty. And in any case, the issue of dualism applies even after you have ratified the treaty. The treaty then, for it to apply, must be transformed. But in this case, we are speaking of an issue which is happening earlier enough in the process of ratification. So in my view, I don't think Kenya is a dual state. I maintain that Kenya is a monoist state. The other finding that I find problematic by the Supreme Court is that the Supreme Court defined the reference to general rules of international law and Article 2(5) to mean customary international law norms, including use covenants, hence leaving all other sources of international law. This is one of the findings that I find quite problematic, because I do not know why the Supreme Court left other sources of international law. For example, the general principles of international law and Article 38(1)(c). I know that our Constitution uses quite a peculiar language of general rules of international law. And that language is a phrase which is not ordinarily used in international law. Yes, it's a phrase which is not ordinarily used in international law. International law uses general principles of law, but our Constitution uses general principles of general rules of international law. Yes, so that one, by using that particular language, but we can say that the Constitution signifies something more than customary international law. Otherwise, the Constitution, like for example, the Constitution of South Africa uses directly the word customary international law, but ours was very silent. It used a rather broad phrase, which is rules of international law. And in that, the only thing that perhaps comes close to that is Article 138(1)(c), providing for the sources of the statutes of the ICJ, which provides for the sources of international law. And that provision provides for the general principles of law recognized by civilized nations. These general principles of law recognized by civilized nations, according to the recent ILC report on the general principles of law, they have identified two potential sources. First of all, the first potential source is derived from the national legal system, and the second one is formed within the international legal system. So let me first start by saying that the general principles of law are distinct from customary international law and use cogens. As a category of sources of law, they are of their own elements, which the ILC Special Rapporteur identifies in the recent report of the ILC on the general principles of law. And these general principles of law, if I may give an example, they are, for example, the good faith obligation, clean and doctrine, the obligation to make full reparation. Those are some of the general principles of law. And that is a recognized source of law. So what it means is that the Supreme Court, by defining general rules of international law, it leaves out this source of law and the many other sources of law which are available in international law. This means that Kenya has fewer sources of international law than any other nation, perhaps, that allows international law to apply. And even more surprisingly is that we do not know why the Supreme Court used the word general rules of international law for customary international law, including use cogens. I wish I would have wanted to benefit from the reasoning of the Supreme Court. Perhaps it would have persuaded me in one way or another. But as we stand, that decision was made without any proper reasoning as to why we have left out the other part. So with that, I don't know whether we'll take a break right now, Luciana, or I proceed to the issue of socio-economic rights. Please advise.
Maybe, Ian, you could take us through your entire presentation so that Maurice is able to respond to the whole of it. I don't know whether that's agreeable.
Yes, that is in order. That is fine.
All right.
Yes. So I move to the second part, and which forms the substratum of my presentation. And this is how the Supreme Court treated the questions relating to economic, social, and cultural rights. I start, first of all, by a finding perhaps that I consider to be a very dangerous finding, and the Supreme Court was of the view, I would want to read this one verbatimly, just one sentence. The right to housing accrues to every individual family by virtue of being a citizen of this country. That was the finding of the Supreme Court, that human rights apply for being a citizen of this country. As a general rule, human rights applies to both citizens and non-citizens. It's only in exceptional cases, and those cases have already been listed by the Constitution, where it uses the word citizen as opposed to a person. I know, perhaps if I may use an example of the refugee, that can be said to be a bit controversial. To some, they might say that the refugees do not contribute a lot to the taxation and contribute to the economy. So why would we be giving them housing? I'm not going to use that example. I'm going to use the example of the stateless persons. People that have lived in this country for the entire of their life, and until recently, for example, the Nubian case would be the most vivid. It means that for the Nubian persons, they do not have the right to housing if we take the ones of the Supreme Court. And this decision, this particular issue has gone before previous other courts when dealing with socio-economic rights. It has gone before the Constitutional Court of South Africa in the case of Kosa versus the Minister of Development. And the Supreme Court of